Right. This is LAWS12066 Land Law, and this is a feedback recording in relation to the final 50% invigilated exam. As you all well know, the exam was of 2 hours duration, and it composed two parts, Part A and Part B. Part A had 2 questions, but you choose one from 2, and the policy style questions. Part B was 2 problem-solving questions. In Part A, question 1 was a question essentially about the rule against perpetuities and the reforms that have been proposed to that rule as reflected in the current law by the Property Law Review 2018. The second question, that's Part A, question 2, related to the topic on social housing, and it asked what benefit would there be for Queensland of adopting the proposal which has been legislated in New South Wales under the New South Wales Act, which implements the Community Housing National Law in relation to the vesting of title in public housing properties to community housing organisations, as well as asking to what extent that was aligned with or supported the Queensland Housing Strategy 2017-2027. So I'll come back to Part A in a moment and just talk more about those questions and about how students handled those questions. Part B had 2 problem-solving questions. Question 1 was a substantial question worth 25 marks. Should just say, of course, that Part A was worth 15 marks. And question 1 within Part B was substantial question, 25 marks out of 50. So half the exam marks were allocated to Part B, question 1. And it was a question on the leases topic. And I think it's fair to say that students were given plenty of foreknotice about the examination of that topic and its significance. And so it was a testing question, no doubt about that. But I think within parameters, it was certainly doable, and that was reflected in the large proportion of students' responses. And I'll come back again to look at some of the detail of question B1 in a moment. So that was a question on leases, topic 7 from the unit. Second question in Part B, both questions were required to be attempted by students. Question 2 was a question on easements, which was the last topic on the unit, and looking at a particular type of easement, how that worked. And students were given, as I said, good guidance in advance about topics that were being assessed in various ways, and indications as to the format of the exam, including the allocation of marks for questions, and so on. To complete the exam, I think it's fair to say students had to manage their time carefully. And I have to say that what I saw in examination scripts was that the great bulk of students were successful in that, in managing their time, in attempting all questions. Some students did write something at the end saying, ran out of time, please understand, ran out of time. Well, okay, you can say the question has required more of you than maybe the time permitted, but that's the question you're facing. You have to do the best you can within the time that's available. And certainly, I would say, in terms of this feedback, is that the great proportion of students attempted all the questions that they were asked to attempt on the paper. That is, gave responses to 3 of the questions chose one for part A, did both questions in part B, and gave quite reasonable responses to the substance of the question. They weren't giving half answers and these sorts of things. So that's a general observation. The other general observation I would make is that I was pleased with the standard of responses by students, and I thought that was encouraging, really encouraging, and I was encouraged by that. There was, in part A, policy style question, there was some genuine attempts to work with the question, to work with the policy documents that it had been indicated that you needed to think about, and not just in a sort of a documentary way, but thinking about the impact of that, which was good. And there was some good attempts, very good attempts across the range of responses in undertaking both questions in part B. So returning to part A, I think it's fair to say that I think there was more students that chose to do question 2 on social housing than on question 1 on the rule against perpetuities. However, those students that attempted question 1, some of the answers were very good. There was a range of responses, clearly, and what was required was you needed to sort of just spend a little time just spelling out the nature of how does the rule against perpetuities operate in Queensland, and that required you to explain that it is an amalgam of both the common law and the reforms that have been instituted under the PLA, and in part 14, and how they work a little bit to some extent, how those reforms under the modern rule against perpetuities as reflected in the PLA provisions have sought to tackle the problems that existed in the common law approach. The question focused on put this statement that the rule is obtuse and obscure and whatever. And this doesn't, we need to get rid of it, basically. So, there's a good engagement with that by most students that attempted the question. But then the response had to go on and engage with the reform focus of the question, and also how the PLA review 2018, what its recommendations were. One of the key recommendations of that review was to enlarge the perpetuity period to 125 years. It made other recommendations with regard to plain language and so on. So the point is that a lot of students that tackled that question did a reasonably competent job, and in fact there were some excellent responses of those that undertook question 1, and showed some insight into the rationale behind the reform proposals and the policy initiatives that have been suggested, and that was part of what was anticipated. And that a policy style question, that's what needs to be done. It's not just about documenting material and initiatives, but commenting on that, explaining the reasons and rationale for that. And what are your thoughts about that? How are you responding to those initiatives? A policy question requires that. You need a reasoned analysis within the parameters of the time that you have, some thoughtful comments within the parameters of the time that you have, and explaining the documents and the initiative, showing that, of course, that you're across the material, but you've also thought about it a little bit too. Question 2, social housing, as I said, I think it's fair to say the bulk of students tackled that. One of the weaknesses there in the question 2 responses, part A question 2 responses, were that there tended to be a bit of a documenting of what's transpired rather than a thoughtful discussion around how this initiative in New South Wales could or should or maybe isn't appropriate in Queensland. That was one of the aims of the question. Not just to say, oh yes, it necessarily applies. Well, it hasn't been actually legislated in Queensland in the way that it has been in New South Wales in the same terms. Well, why is that? And then maybe should it or shouldn't it? And provide basis of that. There was a need to talk a bit about the legislation, maybe some of the provisions from the New South Wales Act, which some students, a proportion of students did, how the Queensland legislation was being needed to be amended, some discussion about the interconnection between the community housing national law and the state legislation. But importantly, the question also required you to comment on this title vesting initiative in light of the stated current Queensland policy through the Queensland Housing Policy 2017-2027. And some students got a bit awry on this because they tended to just document the things that the strategy had developed. Well, that wasn't the question. The question wasn't about telling me what the policy was about and what it was going to do in a whole lot of ways that didn't actually relate to this initiative of vesting of title. The purpose of the question was to see, was there any alignment or maybe lack of alignment, conflict, get you to comment on, discuss and comment on to what degree could that legal initiative, which has quite a clear property law implication in terms of a title going from essentially government to community housing organisations, and the currently stated Queensland policy strategy. I don't think it's fair to say that many students picked up on the fact that this idea of vesting is actually gifting, and that essentially that these community housing organisations or providers were not paying for these properties. And there's a dimension, some good answers dealt with the issue of community housing agreements that exist under the New South Wales legislation, which is true, and mechanisms for mortgaging, and mechanisms to somehow protect the public interest post-vesting. So there was a range of matters that needed to be reflected upon there. And as I say, there were a range of responses, some good responses certainly in part two, but there was also a tendency to document rather than critically appraise and discuss this link between this legal strategy and does it work, should it work, could it work in Queensland, and the stated current Queensland housing policy. And in part A was worth 15 marks, and you needed to, to score well on that question, you needed to explore all of those dimensions in both of those questions, whichever one you decided to tackle. And there were some really good responses, which was great, but there was also some responses that were just documenting material and weren't really being thoughtful or reflective and critically evaluative about the policy initiatives, and that's that's sort of what I was looking for in that style of a question. Different to a problem-solving question, but you still need to be using sources of law, sources of policy to inform your discussion and what you're saying in relation to the question posed. All right, so we're moving into part B, two questions there. Question one, the substantial questions I mentioned before about leases, and question two about easements. Now, coming to question one. Quite an involved fact situation which you had to marshal fairly readily and work out what was going on. Essentially, basically, we had two potential leases being created from the lessor, the landowner of Raymond, in favour of Pam, one potential lease, and in favour of Alice, another potential lease. Now, in any question of this nature, just like in any legal problem-solving question, you have to establish what do you actually have, okay? So you can't make assumptions that, for example, yes, there is a lease, and it's because it seems to suggest it's a lease, it talks about leases, or giving a leasehold interest. No, you have to establish, do we have a lease? So for each of those potential lease situations of shop 1 and shop 2 of the housing complex, of the shopping complex that the shops were in being proposed to be leased by Raymond, you had to say, well, are the legal requirements, property law requirements for the creation of a lease there? That is, do we have exclusive possession? Do we have certainty of term? Bulk of students dealt with that, which was good. Okay. In a question like this, given the time parameters, and you had 2 situations to deal with, Pam and Alice, an efficient way of dealing with that would be to get the creation and formality issues out of the way with regard to both first. That's one way. Another way is just to do it discreetly, but make sure you deal with it. So you had to deal with those questions about, do we have a valid lease? There were issues also with regard to this was Torrens title land under the Land Title Act. So what were the implications there in terms of registration or no registration? There was information about the registration of the lease with regard to Pam, which was good, needed to refer to sections of the Land Title Act. And you then had to, did you have an agreement to lease, or did you actually have a lease, property law lease, right? And certainly in Pam's case, that was manifested through the facts, and we had the various information that supported that, including the registration of the lease and so on, specification of term, rent and so on, and some covenants that had been agreed between the parties, lessor and the lessee. With regard to Alice, it's a different situation. So it was not a specified term. It seemed to be more informal, more casual. Question arose then, do we have a lease? Do we have a license? I think it's pretty clear on the facts once you've moved through it that you had actually a lease, a periodic lease. It was week to week. It was a short lease, so therefore it's an exception to requirement of registration under the Land Title Act. Many students pointed that out. Some students got confused and they came to the conclusion that this was a license and not a lease. I don't think that was the right outcome. But I was happy to continue to read through students' responses that arrived at that wrong conclusion to see if they were going to further argue the other dimensions of the question. So once you got over establishing, yes, we have a lease and a lease between the entities Raymond and Pam, Raymond and Alice, the next aspect of the question that arose was dealing with the covenants that had been between the parties. And there you had to look at the express covenants because there were specific things that were documented in the facts, covenants implied by general law, and also covenants implied by the PLA. The best answers, of course, documented that well, but adapted it to the facts at hand. Again, this wasn't just going through and producing a shopping list of all the covenants in order. Which were the ones that arose on the facts, and how did the facts engage with those issues around repair, issues around express payment of rent, even though, of course, we know that's not a characteristic of lease, but it was evident in both of these situations, which became important a bit later, as we'll come to shortly. And so you needed to look at the sources of those covenants and how they work with and document that against the law, referring to the relevant provisions of the PLA, section 105, section 107, subsections, paragraphs, and so on. Relevant case law, right? Just a point on referring to case law. Some students continue to provide citations in their exam answers. Folks, that is unnecessary in an invigilated exam. You do not need to provide the citation reference. Irrelevant, waste of time. All you need to give is the case name and then how it applies to the facts. You can do that in various ways. You have to be efficient about that, obviously. But you're trying to pull out the rule or the principle that that case provides that assists in the argument you're presenting. Legislation, the same. You can use the full name of an act when you first refer to it, and then you can abbreviate it. Land Title Act, LTA, Property Law Act, PLA, no problem. And you can proceed like that. You just need to be efficient. This is about good exam technique and understand what's required and what is unnecessary in an invigilated exam, particularly when you're on a tight time frame of 2 hours. So once you move through those covenants, of course, then you had to look at breaches of covenants, because you were specifically being asked what were the rights that could be, that Raymond had against the parties, or the lessees. And in particular, you were asked whether or not Raymond could terminate Alice's lease, or Alice, what Raymond believed he had with Alice. And so that took you into breach of covenants. One thing that a lot of students did was they because of information about securing tables and chairs and so forth outside the premises of the shop, a lot of students extended their sense of understanding of the premises to that outside area. Well, that generally in a shopping complex would be common property, and but there was information in the facts which some students well pointed out about an undertaking to comply with the rules of the complex. Okay, so that was in addition to in regard to matters of dealing with the shop itself. So some students tried to argue that that was actually doing things beyond what was permitted, and that what would be Raymond's redress in that situation. There was also information, of course, about Raymond's dodgy repair job of the wall between the two shops, and that was raised in terms of by most students, I think it's fair to say, in terms of both the implications with regard to inherent defects, but also potential danger for occupants and invitees of premises. Some students were also tried to argue that what Alice did, we'll come to Alice just in a moment, in drilling holes in the wall and so forth, contributed to the cracks. And that was fair enough. I was happy to entertain that. But it's also this inherent defect that it was, just, if not to some, if not to a large degree, down to the fact that the job hadn't been done well in the first place. And then the issue was about, so what were the rights that Raymond had against Pam? What was the nature of the breaches which she'd committed? She'd basically put these chairs and tables outside, and she was worried about some interference from Alice. And there didn't seem to be enough there to be suggesting that the action that could be taken by Raymond would be too severe. Certainly wouldn't amount to enabling Raymond to terminate the lease, and so on. But certainly rights with regard to Pam in terms of maybe some rectification, compliance with the rules, and so on. With regard to Alice, then this was a different situation, because Alice, once you've established there is a lease in place, Alice is actually in arrears of rent. Raymond comes along, Alice is out of situation. Some students tried to argue that Alice had abandoned the shop. I don't think that was really the case. She was basically on an overseas trip to acquire garments for her business, which is what fashion houses do. And what action could be taken against Alice in particular, in light of this type of release that she had, given its lesser degree of certainty and protection, as opposed to a lease, for example, like Pam's. And given the arrears of rent and so forth, what could Raymond do? Well, of course, Raymond can do various things, and in fact, he can take action to terminate the lease. But quite correctly, many students pointed out that that requires notice to be issued, and there's certain requirements with regard to the issuing of that notice. And then some students pointed out, well, Alice is not there, so how does that work? That was good to point that out. And then once that had been done, yes, the lease could be terminated. And then the next issue was, well, what could be done in terms of recovery? And that brought into play the issue around taking action for damages, the contractual type remedies, comment the damages that are available, and the relevant case law that deals with that needed to establish that there was a breach of fundamental term of the lease, which is what's been required. In a sense, you're claiming damages for loss of bargain, and that needed to be explored. Many students, explored those dimensions, but a lot of students missed that aspect of dealing with Alice. And then, of course, the last aspect was there anything that could be put forward by way of set-off in any action that could be taken? If Raymond was actually going to forfeit the lease, which is effectively, this idea of terminating, forfeiting the lease basically means that Alice is relinquishing possession of the lease or of the shop. Flip side of that is what is the law in regard to relief against forfeiture, and will equity come to Alice's aid in that regard, and how does that work? And then lastly, that last dimension that I just mentioned is that in relation to set-off, where there was a damages claim, and could there be any potential set-off being made by the lessee? So there's quite it's a fair bit to deal with there in an appropriate way. Most students navigated their way through that minefield. Some fell off at the end, particularly with regard to looking at the full dimensions of forfeiture and relief against forfeiture and the contractual remedies. The very best answers and explored that in a comprehensive way all the way through, and it was very pleasing to see that in some answers. But generally speaking, competent responses to question one. I was pleased by that, but I knew that question one would challenge a range of students in different ways. But it was good to see general competence in terms of how students were handling that question, which was good, because the point is that that's an important area, commercial leases essentially, which was being tested by that question. Just one last little thing. The instructions specifically said ignore the RSLA. Despite that, we still had a few students insisting that we need to consider RSLA provisions. Folks, please, if you're given specific instructions to do something, to think about something, to ignore something, please make sure you follow those instructions. They are not there because I've got nothing better to do. They are there because that's what I want you to be focusing on, or to, no, don't deal with that because that's not relevant. Follow the instructions, very important, okay? All right, so moving on to question 2 in part B, easements. Now, I think it's fair to say that this question was done quite well by most students. It was worth 10 marks. And again, basically, it was a question in dealing with an easement of way, a right of way. And rights of way, there are provisions within the PLA that deal with that. But again, you had to go through and set up, well, it looks like an easement, but actually have we got an easement according to property law? So you need to go through the tests of determining whether we have an easement. Ellenborough Park, the 4 dimensions of easements. Good students identified that one of those dimensions is no longer relevant in Queensland. That is that the dominant and servient tenement has to be different. Land has to be held by different entities or parties. That's been changed by legislation in Queensland. And then going back and looking at the facts to see whether those elements have been established. Have we got a dominant tenement? Have we got a servient tenement? Benefit and burden. What's the nature of the easement? Well, it's an easement of way. And when we've got that established, the central focus of the question after that, but you needed to do that, it's important, was whether or not the easement had been extinguished, either by abandonment or other mechanisms possibly, and then to explore and against the facts as to whether or not that actually could be established. There was an alternative access to the park. There was information about the fact that the current right-of-way was a bit overgrown. There was partial obstruction from a fence, that the dominant tenement, actually the owner, Hamish, had put some boxes there for wildlife protection. Various facts to talk about. And you had to basically keep coming back to the facts, using the legal framework, coming back to the facts to see whether or not Gwen, who was the person seeking to request advice as to whether or not she could continue to use the right-of-way and that easement could be maintained, whether or not that was established. And I think it's fair to say in the end that there probably wasn't enough to suggest there'd been extinguishment of the easement in various ways. Of course, how the easement had come into being created needed to also be discussed in the early part of your response. Queensland easements by longer user by prescription alone is no longer can no longer create an easement. But if other factors and other aspects and features and agreements and so forth come to bear, that will be satisfactory. Some students spoke about maybe as of necessity and so on, but that was a dimension of explaining how this easement arose in the first place, and then looking at the issue around extinguishment, whether it was extinguished, whether it wasn't. Some of the best answers then also provided some very useful practical advice to Gwen in terms of what she could do, how she could go about ensuring that she could continue to have access to this right-of-way and so on. So generally speaking, I'd say it's fair to conclude that part B, question 2, was done quite well by a lot of students. The weaker responses just assumed it was an easement without exploring the dimensions of what it is needed to establish an easement. But many students, I think most students, picked up on the extinguishment aspect of the fact scenario and explored that. I think it's fair to say that overall, the performance on exam was quite good and quite solid, and I was pleased about that. The highest mark on exam, I'm happy to reveal the highest mark, outstanding paper, which was 49 on 50. I think it's the highest that I've given, and it was an outstanding exam paper. And look, thanks for all your efforts in the unit, and as we've travelled through land law together. Land law is a demanding topic, a demanding subject. It has substantial body of case law, and it also has legislative technicality, which presents challenges. And it also has spatial dimension, which is not something that arises in other areas of law, where you have to have a sense of the spatial dimension of how land functions and exists and how the law impacts on that. I mean, easements is a very good example of that, for instance. There we are. There's feedback on the invigilated exam, and I just finished by wishing all of you the very best for your future studies in the program as you continue forward. And as we're finding ourselves here at the end of term 2 and in November, I just want to take this chance also to wish all of you the best for the conclusion of the year and the festive season, Christmas in the following month, and also for the new year. So, bye for now.